I'm Nancy Nicolescu, Director of Education and Communications for the Office of State Ethics. The State Ethics Commission was originally established in 1977 after Watergate. In 2005, the legislature passed sweeping good government reforms, which created the Office of State Ethics as the successor agency to the former commission. We are a civil enforcement agency responsible for code of ethics for public officials, state employees, lobbyists, and contractors. We are called a watchdog agency because we watch government. The Office of State Ethics is a small agency. We currently have 15 employees, and our executive director is Carol Carson. The Citizens Ethics Advisory Board is the governing body of the agency. It's comprised of 9 citizen volunteers who are appointed by the governor and other legislative leaders. Our board meets monthly. Our agency promotes high ethical standards in the state of Connecticut. We provide advice, guidance, and education about what can be a complicated set of rules. For those who don't comply with the codes, our role is, when necessary, to fairly and vigorously enforce the applicable codes. This can result in fines of up to $10,000 per violation, referrals for criminal prosecution, and other penalties. The ethics code is common sense. One of my favorite quotes is a quote by Judge Potter Stewart, which states, "Ethics is knowing the difference between what you have a right to do and what is right to do." Sometimes knowing the difference between right and wrong is easy, but more often there are areas that are not as distinct. The code exists not because public officials, employees, lobbyists, and contractors are bad, but because they're human. I believe that each and every one of us gets up every day, goes to work, and we do the best job that we can. But imagine that you're driving through a small town that does not post speed limit signs, and when you get to the other side of town, there's a police officer waiting to give you a ticket for speeding. That wouldn't be fair. Ethics training is a mandatory annual training, and it is my hope that this training will provide you with the speed limits so that you know how fast you can drive when it concerns the code of ethics and how it applies to you every day. Today, we're going to cover the top 10 rules for state employees and public officials. We will discuss our major areas of oversight: gifts, use of state position, and other employment. Please note, I will not cover every provision of the Code of Ethics in detail. This is intended to be an overview, a refresher training. First, the obvious. You're watching this because you're covered by the Code of Ethics as a public official or state employee. Lobbyists and contractors are also covered by the Code of Ethics. What's the point? When I say the word ethics or ethical behavior, a few thoughts may come to mind. For example, right and wrong, integrity, moral behavior, values. Certainly, each and every one of us thinks of something different because our moral compass is different for each of us. It's based on our religion, our culture, and what we do for work. My right and wrong is not the same as your right and wrong. Regardless of our moral compass, the main point of the code has to do with using our state position to put money in our pockets. It always has to do with financial benefit. And sometimes money does not look like Benjamin Franklin's. It can look like a number of different things, like gifts or contracts. The first rule, and the most important rule, is to always get advice. There are a number of ways to do this. First, you may want to seek advice from your ethics liaison. Every state agency has an ethics liaison, and they can provide you with advice concerning the code or act as the intermediary between you and our office. Second, you may contact our office directly. No one gets up in the morning and says, "Today's the day that I want to call the Office of State Ethics." But if you do, 99% of the time when calling into the Office of State Ethics with a legal question, you will be transferred directly to an attorney. You can receive informal advice verbally, in writing, by letter, fax, or email. Or you can request formal advice from our Citizens Ethics Advisory Board. We are a resource for you at any time. Remember, if we provide you with advice, you can rely on it. During our training today, I will be referring to the Code of Ethics. But please keep in mind that every state agency has its own ethics policy, and it may be more restrictive than the code, but it cannot be less restrictive. You should familiarize yourself with your agency ethics policy. The second rule is about gifts. As a practical tip, as state employees, we should not accept gifts. However, there are some exceptions. And before I get into that, I wanted to discuss 3 types of people that can give you gifts. The first type is what we call a restricted donor. A lobbyist is a restricted donor. Most of you would say you don't work with lobbyists. That is because when we're thinking of lobbyists, we think of those individuals that wear badges and communicate with public officials at the Capitol, and that's true. In Connecticut, they're called communicator lobbyists. But they're paid by their clients to communicate. And their clients are also registered as lobbyists. And we deal with these clients or big corporations every day. So if you'd like to know who exactly is a registered lobbyist in the state of Connecticut, you can simply call our agency and we will let you know. Or you can visit our website to review the list of registered lobbyists. In addition to the lobbyists that I just discussed, restricted donors also include persons that are regulated by, doing business with, or seeking to do business with your specific department or agency. This also includes building contractors that are pre-qualified by the Department of Administrative Services to do business with the state of Connecticut. The next potential source of a gift is what we refer to as a non-restricted donor who is giving you a gift by virtue of who you are in state government. I'll give you an example of this. Say, for example, that the University of Massachusetts asks me to come give a lecture on ethics laws in the state of Connecticut, and I go there and I'm in my official capacity as Director of Education and Communications. I give a speech, and when I'm done, UMass wants to give me a bunch of gifts, sweatpants, t-shirts, hats, stuff like that. Now UMass is not considered a restricted donor. They're not registered lobbyists in Connecticut. They're not seeking to do business with my agency. We don't regulate them. But here, that unrestricted or non-restricted donor is giving me a gift because of who I am in state service. In other words, if I wasn't the trainer for the Office of State Ethics, I wouldn't be there and they wouldn't be giving me a gift. Then, the other type of donor is everyone else. Your mother, your father, your brother, your sisters, and your friends. They're considered to be non-restricted donors, and there are no limits as to what they can give you. But there is something to remember here. Once your best friend becomes a lobbyist, then he or she falls into the restricted donor category. So what is a gift? A gift is anything of value directly and personally received unless consideration is given. The statutory definition of the term gift is this: anything of value that is directly and personally received. And a gift, and what that means is that a gift could be just about anything. It could be cash, it could be food or beverage, it could be a ticket to a sporting event, it could even be a rebate or discount. It could be just about anything. A gift is directly and personally received. Now what this means is that the recipient has accepted the opportunity to partake or utilize the particular item. So I'll give you an example. Say, for example, that a contractor that I work with gives me tickets to a hockey game. Later that evening, I realize I should not have received that gift. So I don't go, or I give the tickets to my neighbor. Even though I didn't go, I still accepted the opportunity to partake in that gift, and therefore I'm directly and personally responsible for having received it. If it's not considered a gift if consideration of equal or greater value is given in return, In other words, if I pay for the tickets or any item I receive, then it's not a gift. Keep in mind, you have to pay what it's worth, fair market value. So if someone gave me a BMW, a contractor that's doing business with my agency, and it's brand new, let's say, I simply can't give that contractor $100 for that BMW and call it even. Now, the general rule is that as state employees, we may not accept gifts from restricted donors, but the tricky part is that there are 19 exceptions under the code. I'm certainly not going to discuss all 19 exceptions, but I will discuss some of the most frequently used gift exceptions. The first exception is a token item gift exception. Now, under this exception, you may accept any item of value that's valued less than $10 per item, like hats, mugs, t-shirts, pens, calendars, water bottles, with an annual cap of $50 from a particular source, a vendor or contractor that wants to give you that token item. So up to $50 per year, no more than $10 per item. So I also want to mention you're going to have to rely on your moral compass here. Sometimes you may receive an item that is worth more than $10, and you have to be very careful. This would be what we would call a prohibited item. And the speed limit is that you return this item, refuse this item, or pay for it when it occurs. During holidays, sometimes restricted donors send gift baskets to our office. Because of the likelihood that a gift basket would exceed the $10 limit, it would not be acceptable for one person to receive it. The Citizens Ethics Advisory Board has ruled that for perishable items, if those gift baskets, fruit baskets, things of that nature are shared by the entire agency or division, then it would be acceptable and does not have to be returned to the donor. The next gift exception is the food and beverage gift exception. Now, under this exception, you may accept up to $50 in food and beverage from a restricted donor per calendar year, provided that the person paying is in attendance. The key point about this is that the person paying or his or her representative is in attendance. So a contractor or lobbyist would not be able to give you a gift certificate to a restaurant so that you could go out with your spouse or your friends later. That would not fall under this exception. The other exception is rebates or discounts. As state employees, we can accept rebates or discounts as long as they're available generally to the entire public. For example, a mobile phone company offers a discount to state employees who sign up. You can accept this discount. However, a contractor that you're working with wants to give you a special discount for services, this you may not accept. This is an example of putting money in your pocket. The discount must be available to all members of the public. Gifts to the state is also another gift exception. And this gift exception permits a state agency to accept goods or services that are provided to the state for use on state property that support or facilitate state action or function. So for example, if a restricted donor wanted to give the Office of State Ethics a fax machine or the Department of Transportation a payloader, that would be perfectly acceptable under this provision because it's for use on state property and facilitates state action or function. The law was recently changed to also allow restricted donors to provide goods and services that support participation of officials and employees at events. For example, conferences, trainings, site tours, provided that those events facilitate state action or function. The Code of Ethics prohibits you from accepting fees or honorarium. So, as a public official, you cannot accept a fee or honorarium for attending any events if you write an article, make an appearance, give a speech, or participate in that event in your official capacity. However, you may be reimbursed for necessary expenses if two criteria are met. if you act in your official capacity and you actively participate at the event. Now, exactly, what are necessary expenses? Necessary expenses include travel, not first class. It's what the state of Connecticut would pay for you to attend an event. So your airfare, bus fare, train fare would be included, lodging. So the cost of your hotel the night before, during, and after the event would be included. Your related meals and conference expenses would be included, and any registration fees. You should note the following 3 important points about necessary expenses. The first one is that necessary expenses do not include tickets to sporting events, golf outings. They don't include anything that's not necessary for you to be there, a Broadway show. Necessary expenses do not include payments for your spouse or guests that are traveling with you. And the third part is that within 30 days of receiving payment or reimbursement for necessary expenses for lodging or out-of-state travel, you must file a necessary expenses form with the Office of State Ethics. I strongly encourage you to call for advice to make sure that, if you're traveling to a conference, to determine if it falls under the gifts to the state provision or the necessary expenses provisions, and that you're filing any of the required documentation that needs to be filed for your participation at these events. I already discussed, this is a very important rule, but it is rule number 3, prohibited gifts. And here's the speed limit. If you receive a gift that doesn't fall under some of the exceptions that I mentioned already, the rule is that you're supposed to refuse it, return it, or pay fair market value for it. If you need assistance in determining fair market value for a particular item, please contact our office, and our attorneys will help you with that as well. Rule number 4, gifts to coworkers. You can give each other gifts. Coworker to coworker, there's no limit. The Code of Ethics covers gifts between supervisors and subordinates, and such gifts are limited to $99.99 per gift. Individuals cannot pool for a group gift over $99. And what this means, and when this usually occurs, is in our agencies, sometimes there's a catastrophic event, there's a fire, there's an accident, and we want to pool, we want to pass the hat and collect a gift for that coworker. If you have subordinates and supervisors in the same pool, the Citizens Ethics Advisory Board has ruled that you're more than likely going to exceed the $100 gift limit. So if you're going to pool for a catastrophic event, you should not include supervisors in that pool. If it's a major life event, and there are 5 specific major life events in the law, and those are birth, wedding, funeral, retirement, and induction into religious adulthood. That means bar mitzvah or confirmation. For those major life events, the gift limit is $1,000 for subordinates to supervisors and supervisors to subordinates. But also, if you were to pool under a major life event, you could pool up to the $1,000. Rule number 5 is use of state position. You may not use your state position for your own financial gain, for the gain of your family, which means spouse, child, spouse, parent, brothers or sisters, or for the gain of an associated business. Using your state position would be a conflict, and we must always remember to refrain from taking any sort of official action if the result of that action would be a direct monetary gain or loss. The exception to this, of course, would be if the resulting gain or loss is the exact same for any member of a large group, such as a profession, all doctors, let's say, or another large group, such as all taxpayers in Connecticut. If you believe you have a conflict, you must abstain or recuse yourself. That's mandatory. But you should also contact our office for the actions that you must take or that your supervisor must take when you're presented with a direct conflict. Rule number 6 is use of office. You should only use state time, personnel, equipment, or materials for the state's business. Rule number 7, other employment. After hours, you cannot accept outside employment that impairs your independence of judgment, nor can you accept outside employment if it requires you to disclose confidential information that you may have obtained or learned of on your state job. Confidential information is defined as information that is not generally available to the public. Remember, you cannot use your position to benefit your outside employer. Very careful about that. If you, a state employee or a public official who exercises contractual, supervisory, or regulatory authority over a prospective employer and/or business, you should not work for that employer. So, an example of this, where it would impair your independence of judgment, or perhaps you should decline accepting this outside employment, would be if a DOT employee were to work for a contractor at their outside employment that they supervise during the day on the job as a DOT supervisor. That would impair your independence of judgment, and these types of things are very important. The law can be complex in these areas, and so we always refer back to rule number 1, and what is that? Get advice. Rule number 8, contracts with the state. Under this provision, no public official or state employee or member of his or her family or business with which he or she is associated with shall enter into a contract valued at greater than $100 unless it's awarded through an open public process. The exception here is a contract of employment as a state employee. Another thing to keep in mind is that executive heads of agencies, their families, and businesses that they're associated with are strictly forbidden from entering into any contracts with their own state agency. Outside business, rule number 9. A supervisor may not hire an employee to work for an outside business. It is also impermissible for an employee to hire a supervisor. Rule number 10, leaving state service. In this segment, I will discuss the provisions that may apply to you once you leave state service. These provisions limit the activities of former public officials and state employees. There are 2 lifetime bans and 2 one-year bans. The first lifetime prohibition is the prohibition on the disclosure of confidential information. Under this ban, you may not disclose confidential information that you gained in state service or employment for financial gain for anyone. Confidential information is any information that is not available to the public, and it can be in any form, whether it's written, recorded, computerized, or verbally transmitted, such as conversations or negotiations. The second lifetime prohibition is the ban on representation concerning matters in which public official or state employee participated. Under this provision, you may never represent anyone other than the state concerning the matter in which you participated personally and substantially, and in which the state has a substantial interest. This is the so-called side-switching provision, and its purpose is to prevent side-switching in the midst of ongoing state proceedings. So, for example, as a state employee, if I'm involved in a negotiation of a contract with a vendor, and later on I end up leaving the state of Connecticut and I end up working for that vendor, if a dispute arises, let's say to the maintenance provision of the contract, which I previously negotiated, I cannot represent the vendor, my new employer, in the contract dispute. This would be switching sides. The one-year bans are on representing others before your former agency. You must cool down. Under this provision, You must not, for 1 year after leaving state service, represent anyone for compensation before your former agency, especially concerning a matter in which the state has a substantial interest. It's permissible for you to use your expertise to impart your knowledge that you gained in state service while working for your post-state private employer or your new employer. And it's also permissible to meet with your former colleagues for social events once you've left state service. But we always say be careful here. Cool off. Make sure you let that 1 year period go by. If you're going to have any interactions at all with your former state agency, again, I refer you to rule number 1 and ask you to seek advice. The other 1 year ban is on contracts over $50,000 signed within the last year of your state service. Under this ban, a former state employee who participated personally and substantially in the negotiation or award of a state contract valued at $50,000 or more may not accept employment with that party for a period of 1 year from leaving state service. So for example, let's say I negotiate a contract with an entity in excess of $50,000. 2 months later, that contractor wants to hire me. Because the contract was signed within a year from the date that I left state service, I could not accept a position with that contractor. And the Code of Ethics does have jurisdiction over not only the state employee in this instance, but also the state contractor. Those are the top 10 rules for public officials and state employees. As we recap, I'd like to go over a few certain important points. The first one is that each state agency has its own ethics liaison and or compliance officer, and each state agency also has its own ethics policy, which can be more restrictive than the Code of Ethics. The law requires certain individuals to notify the Office of State Ethics if they have reason to believe that the code has been violated in any way. And the mandatory reporters for violations of the Code of Ethics for public officials are commissioners, deputy commissioners, state quasi-public agency head, and deputy head, and any individuals in charge of state procurement or contracting. Your ethics liaisons or agency ethics compliance officers are not mandatory reporters. They're there to coordinate ethics training for your agency, to make sure that you're meeting the annual mandatory training requirement, to work on and develop ethics policies for your agencies, and they're there to help make sure that you get the advice that you need so that you're in compliance with the Code of Ethics. It's extremely important for you to be familiar with the ethics policy at your agency. When agencies develop their own internal ethics policies, they may by law be more restrictive, as I've stated. For that reason, it's a very good idea for you to become familiar with your own agency's policy and how it may differ from what you've already heard. Your agency's policy should be on file with the Office of State Ethics, and it can also be obtained from your agency's ethics officer. Ethics enforcement. So far, you've learned a lot about the rules that govern ethics in the state, and the penalties for the violations to these rules can be quite serious. I'd like to spend a couple minutes on ethics enforcement. Ethics complaints stay with you forever. What you need to know about our enforcement division is that you can contact us at any time and leave an anonymous tip. And then our ethics enforcement officer can initiate a complaint based on that anonymous tip. Or you can submit a complaint in writing on our official complaint form. Complaints have to be filed under penalty of false statement. And if it is later found that a complaint was filed with the knowledge that the allegations were false and that in and of itself is a violation of the code, and the filer of the complaint may be liable for double damages to the person against whom the complaint was filed. Remember, I said ethics complaints can stay with you forever, so we take complaints very, very seriously. What's really important to know about filing a complaint is that whether you file it anonymously or in writing, the allegations of the complaint are strictly confidential. You too are held to those confidentiality provisions. So you can't call the press to let them know that you filed a complaint against a coworker. That would be a violation of the Code of Ethics. Confidentiality is lifted and the file becomes public only after one of three things happen. First, after there's a probable cause hearing, if a judge trial referee finds that there is probable cause that a violation has occurred, then the file would be public. Second, at any point in time, the respondent of a complaint may ask for the complaint to be public, at which point we would comply with that. Finally, if the respondent settles the matter prior to a hearing or a probable cause determination, then it would also become public. The Citizens Ethics Advisory Board sits as a jury in most of these matters. If the board finds that there's been a violation of the Code of Ethics, they may order you to do a number of different things. First of all, they can issue an order asking you to comply with the code in the future or asking you to cease and desist your current activities. Second, the board can require an individual to file any required report or statement. And finally, and most significantly, the board can order payment of a civil penalty of up to $10,000 for each violation of the code. In many cases, the board can order that the violator pay back whatever financial gain has been received as a result of the violation. And this too can amount to significant amounts of money. As for any of these, if the board believes that there's been a violation of the criminal statutes of the state, the board can also refer the matter to the state's attorney's office. In closing, I like to leave you with this quote, one of my favorite quotes by George Orwell. On the whole, human beings want to be good, but not too good and not quite all the time. As you've heard through this training, there are many rules that you must be aware of and that you must comply with, and severe consequences for violating the code. And as I said at the beginning, this is a brief training, the top 10 rules, and by no means does it cover the entire Code of Ethics. So I'd like to leave you with some common sense tips for thinking about these issues as they present themselves to you. First, when in doubt, don't. Refer to rule number 1, get advice. Next, try the media test. Write the headline. How does what you're going to do look on the front page of one of Connecticut's major newspapers? If that makes you uncomfortable, get advice. The Office of State Ethics is available for all public employees, officials, lobbyists, contractors who need education and advice or guidance about the Code of Ethics. What should have come through to you in this presentation is that we are not a gotcha agency. We really want to help you get it right. So I encourage you, visit our website at www.ct.gov/ethics or give us a call at 860-263-2400. We look forward to assisting you with your questions. Thank you again for your attention and have a great day.